Greetings. This is attorney Della Welch, and this is tape 3 concerning some of the basic definitions and terms in California workers' compensation law. We talked briefly on the last recording about WCJ as the workers' compensation judge, and he issues or she issues a decision. If you don't like it, 20 days after the decision is served, then you can file a petition for reconsideration. And then if you don't prevail there, you may want to take a writ to the appellate court, to the next level of appeal. Usually now it's very hard to take a case to the California Supreme Court. Here is a question for you. What can the employer do to assist the insurance company in processing the workers' compensation claim of an injured employee? Well, one thing the employer can do is provide information about the employee's outside activities. For example, they may have filed a workers' compensation carpal tunnel claim, claiming they got carpal tunnel at work, and yet there may be some apportionment to outside activities. Maybe they crochet, maybe they play the piano. I had one case where a person, by an agreed medical examiner, the report rated 100%. And what they didn't know is that this person outside activities, she went to university and was an outstanding student, and she was getting A's in calculus, trigonometry, and very difficult subject matters. Another very good tool would be surveillance. I had a case where someone claimed serious herniated back injury, and yet his outside activities is he was a football coach, and we got film of him playing football and doing all the kinds of things he told the doctor he couldn't do. So this area is very ripe with fraud in the activities. I had one case where the employee said he could only lift up a table fork slightly with his left hand. Well, the thing he didn't know, I had him slamming doors and repairing cars and doing everything. So I showed that he was completely unreliable. So if we know their outside activities, their hobbies, outside jobs. Another thing is subpoenaing records. I had one case where the person claimed no prior stomach injury, and yet I was able to subpoena his records, and at age 19 he had that same stomach condition, and he'd given the wrong history to the doctors and didn't include the incident at age 19. So subpoena is a discovery method, and also surveillance. Now, one of the things that is important is the stress claim. The history of the stress claim in California is kind of interesting. It used to be in the government under Pete Wilson, the work had to cause 10% of the stress claim, and then it went to 51%. But right now there's special rules that if the stress is because you had some physical injury, it's not work-related. Generally, you have to be an employee for 6 months. I had a case where the person was 3 days short of 6 months. Well, they hadn't reached the statutory 6 months, so he was not, or she not able to recover. So this has been cut back over these several years. Stress of litigation is not compensable, so you have to really have something bad. It can't be just some ordinary personnel action, and you may want to seek counseling rather than filing a stress claim, because what happens is it opens up your entire medical records. I had a case where someone wanted to file a stress claim, claiming they were stressed at work. And I said, well, I want your entire psych records. And she said, no, I don't want to provide it. I have pre-existing conditions. So I said, well, you better drop your stress claim. I told that to her lawyer. And she did drop the stress claim, because all of your records, marital problems, all these things will come in. So this is something that you really need to think over and discuss it with your attorneys. Usually the attorneys will see you without charge, and when you get your final award, they will take like 10-15% or something. So it's much larger, much a smaller portion than in personal injury. So let's go through a problem here. If you receive a report that cancer impacted a herniated disc, what may be an appropriate remedy for the insurance carrier? Pay the claim, you have no recourse. Deposition the medical doctor to determine if his mind has been changed or whether or not weaknesses in his opinion may be noted. That's the best answer. Deposition is our great tool, attorneys, to find out the basis of his opinion, and then if you can, challenge each basis of the opinion. I had one case where the doctor said his opinion was based on the fact he was a doctor. Well, that wasn't enough. He has to have some research or some scientific basis. So the basis of the opinion is very important. Here's another question. How long does an insurance carrier have to deny a claim for workers' compensation injuries? The answer is 90 days. What is the impact of a late denial? Well, there's a presumption of compensability, and usually what happens is the insurance carrier pays for the claim. So that 90-day period is very important. I always tell employers, if they can, to calendar that date and check with the insurance company and make sure the proper acceptance or rejection of the case has been made. Can surveillance films be taken of the injured by the insurance carrier? And yes, that's a very powerful remedy to see them doing those things that they're telling the doctors they cannot do. So that's one of the very greatest tools. So this is some of a general discussion of the terms in workers' comp. You can read in the labor code and get more information. Or law libraries have the workers' compensation cases that you can read. Some people are workers' compensation agents of the employer and work with insurance companies. So hopefully this information will be helpful to you. And remember to check with your own legal counsel. This is designed to just provide helpful information. This will be the end of the recording in workers' compensation law in California.